recording. Hi, my name is Jamie Bilsbach, and I'm Center Director for the Central Mountain Small Business Development Center. And joining me today is my colleague, Devin Dean, who is the Client and Program Coordinator. And it's our great honor to bring Nathan Lawrence. He's the founder of Principal Law. And I can remember Nathan reaching out to me, gosh, before COVID, and saying that he was a new lawyer in town in Salida, but then shared his vast experience with tech and entrepreneurs and small businesses on the front end. Front range, I always say front end, I don't know why. Anyway, Nathan is presenting People Ops, the best practices in employment law today, but I wanted to share that he'll be offering these other 6 legal training events for small businesses. So I welcome for you to join us and register for those. And after their live time, they will be also available on demand for the year. So next slide. We're the Central Mountain SPDC, but we're part of a larger network and throughout Colorado. Our center is supported by our host, Chaffee County, and co-host Lake and Park counties. We're funded through the SBA, and we're managed and funded through the Office of Economic Development and International Trade. And you can reach us on our website for consulting services that are free, confidential, with local consultants as well as statewide experts. And then also attend all of our workshops, as well as have access to statewide workshops and our annual Power of We, which is a women's entrepreneur conference. Next slide. And this, you can see us, the little yellow in the middle. We're actually the smaller center, but I just wanted to show this map so that you know you can get statewide support anywhere throughout Colorado. And they also offer tech support and many other programs. So now it's great, with my great pleasure, to pass it over to Nathan.
Thank you, Jamie. Appreciate the introduction and the kind words, and it's always great to be working with the SBDC and all its wonderful members. A little about me. I am an attorney. I was first a small business owner. I owned small businesses and worked with attorneys and paid lawyer fees, so I understand what that's like from the business owner's perspective as well. I've been in Salida for about 4 or 5 years now. I went to the University of Colorado twice. I practiced in big glass buildings in Denver coming up and learned a lot of stuff. Worked really hard, and I'm glad to bring that experience to the Central Colorado. So a little bit more about my firm. We are small business and startup specialists. So what does that mean? Startup law is one thing, usually involves a lot of capital raising, fundraising, dealing with securities law issues, etc. for businesses that intend to grow large. Small business law is, businesses aren't necessarily that small, but they're not publicly traded. They are, typically not trying to find institutional, like venture capital investments. So those are the 2 types of businesses that we focus on. In doing so, we have a broad practice. We work in employment law, corporate governance, basically how you work with your partners, how you choose how you arrange the operation and control and economics of your organization. We do intellectual property, real property, commercial transactions, and many other subjects. My partner, Max Montag, is a new partner this year, and he handles litigation. So if you have disagreements, Max can help you out. If you want to make an agreement or prevent any disagreements, that's when you call me. I'm what you would call a transactional lawyer. So Word of the wise, call me so you don't have to call Max, but we'll get to more of that in a bit here. Again, as Jamie said, please feel free to raise your hand and ask a question or put a question in the chat. I think I'll be able to see that. I'm sure Jamie or Devin will let me know if not. And anything we discuss in this session is not confidential, just to be very clear. Even if it happens after the recording ends, I am offering free half-hour consultations to anybody associated with the SBDC. So, and the duty of confidentiality, the attorney-client privilege, is the same for actual clients as it is for prospective clients. So if you have something confidential you want to discuss, we can do that. We can do it at no expense to you. But I would prefer you didn't put yourself in legal jeopardy by stating it during the session. So, all right, one last kind of housekeeping item. This is general guidance for everybody. I'm not addressing specific situations. There are law is complex. There's a reason why we got to go to grad school to do this. So this is general advice only. It is not specific legal advice. And you should speak with me or another attorney before applying it in, especially any kind of a disputed situation, but really at all. So, all right, that wouldn't be a legal presentation without a disclaimer, right? So with that done, we'll move on and talk about what we're actually going to talk about. So. Employment law, this is a big area of where prophylaxis is important for companies. If you treat your employees well, in good faith, you have good policies and practices in place, you're almost certainly going to avoid employment disputes and employment litigation. Unfortunately, most employers don't do that, and there's a reason why. It's quite complicated. There's many tedious, long books written on the subject. I've read quite a few of them. Here's one that you can see. It's difficult to comply with everything, but it's important that you do, to avoid paying my partner Max twice what you're going to pay me to help you get it set up in the first place. So in any case, here's the agenda. First, I think it's important for us to have a general understanding of the purpose of employment laws and where they came from, how they evolved, just because it's essential to understand why the regulators are doing what they're doing in order to be in compliance. It's not all black and white, and following the spirit of the law is often a safer strategy than following the letter of the law, but we'll get into that more as well. Next, we'll talk about worker classification and who is, legally speaking, an employee. And we'll talk about issues around calling or classifying employees as 1099 employment independent contractors improperly, and what contracts or policies are appropriate for each. Then we'll talk about the concept of at-will employment contracts, and why most employers should prefer policies over contracts for their employers. Next, we'll discuss employee separation, which is, nobody likes, but it happens frequently when the employee and the employer part ways, how to do that correctly, how to cover yourself there. And then finally, we'll talk about, Colorado laws specifically that employers must follow, and we'll discuss how to avoid getting sued by your employees, which is, I think, a topic everyone that has an employee or is thinking about having an employee will be interested in. All right, so a little bit of background. As I said, I think it's important to understand why employment laws are the way they are in order to be able to follow them more faithfully. So, originally there was this master-servant relationship, back in the feudal days when, nobody except nobles owned property and everybody leased the land, and, there was really quite a disparity. So what that led to was, eventually some of the workers got fed up with simply, doing what they're told for almost nothing, and led them to demand fair pay for fair labor and other equitable concepts that we generally recognize now in employment law. With the onset of the Industrial Revolution, workers went from a dispersed agrarian model to a centralized city-based model and began organizing and demanding rights. Information was easier to pass around. So, at this point, there started, this is the early 20th century, we've started to see labor activity. We've started to see employees demanding fair pay, organizing to actually get it. And then the government starts paying attention to that and passing rules and regulations to enforce those fair pay and fair labor conditions concepts. Simultaneously, as professionalism developed and it became more important to have a good CEO or COO or whomever, engineer, companies started offering perquisites or perks. It's something that's regarded as special right or privilege enjoyed as a result of one's position, and that was as an incentive. But by the end of the mid 20th century, these two things had combined into a system where the government decided to codify most of the protections for labor, and then also throw in there a lot of the perquisites that were originally offered as incentives and made them requirements, such as health insurance above a certain amount. And the result is essentially that we created a benefits regimen that employers are required to follow and provide for their employees. And the level of benefits, as you'll see today when we talk about Colorado law, is expanding on an annual basis. These laws are changing and requiring more and more of employers every year. And that's how we've decided to handle providing safety nets in this country. It's sort of a capitalist approach where we put it on the employers. I think in other more socialist democracies, you would see a lot of these programs being directly sponsored by the government. But that's what we have here, and it's something that you all will have to comply with. So it's good to know about. All right, the first topic is, what is an employee? What is a contractor? When do I have to call worker who's performing services for me an employee, and when am I allowed to call them a contractor? A lot of, especially small businesses, prefer to hire contractors. There's just a lot less hassle associated with it. There's a lot fewer requirements. Most of the requirements we're going to discuss today do not apply to independent contractors. And it's generally cheaper to employ independent contractors. That said, it's usually not the case that if you have someone working for you, that person is actually a contractor. And in Colorado, there's a two-part test that says a contractor is a worker who is free from direction and control. Basically, just think of a roofing contractor. Someone shows up, you say, I need a new roof. They say, okay, we'll get it done next week between Monday and Thursday. And you say, okay, how much? And they say half now, half when we're finished, or whatever. That's really what the government means when they say a contractor. That roofing contractor is not going to ask for your permission, use your tools. You're not going to train that contractor. That person is engaged in an independent trade, and they are free from your direction and control. Whereas a lot of folks we want to call a contractor, like let's say, I'll think of a near and dear one for me, which is having a nanny. I have a small child, and there's limited options, or so we do a nanny share with a couple other folks. And the fact is that while we love to call that person a contractor, they're working for us in our home at our direction during the hours that we dictate, using the equipment and tools that we provide. And that person's not working for anybody else. That's an employee. And so those are kind of the two extremes you might see as far as independent trade or business and direction and control. So how do we determine whether somebody is an independent contractor or a employee? Well, we look at the whole circumstances, and so there's quite a few factors that go into it, but it sort of comes down to, if it looks like a fish, swims like a fish, it's probably a fish. So you can use common sense for the most part, but some of the factors include whether the employee or the worker uses your tools, whether the worker receives training, whether the worker does the service for other people as well. whether it's simultaneously or, at different periods in time. Whether the worker holds himself out as an employee, such as being assigned an email address with your company's name on it, et cetera, et cetera. Again, if it looks like an employee, the Department of Labor is probably going to treat that person as an employee. Okay, so why do you care, right? I mean, it's one thing to do it or not do it. It's another thing to get caught and punished, right? So there are some penalties. It's up to a $5,000 fine per misclassified employee, up to 25 for subsequent violations. If you work with the government, if you work with the state of Colorado, you can be banned from doing business with the state for 2 years if you violate this rule. And additionally, you'll have to pay back premiums on unemployment insurance taxes and other taxes associated with that, plus interest. And eventually, if you just continue to refuse to comply, your business can be shut down. So I've had a case. I've had many cases, but one in particular, where we appealed this all the way up to the highest authority at the Colorado Department of Labor. A worker was hired by a placement agency as an independent contractor. She worked from a different state, used her own equipment, made her own hours, was paid on a case-by-case basis and not hourly. She was provided no training, chose which clients she worked with, had no stake in the profitability of the business. But she did not have her own company. She did not carry insurance. Her primary job was a school teacher, but she worked as a placement agency, worked for my client, placement agency, and she worked for other placement agencies before and after the period in question. So is that a contractor or an employee? We sure thought it was a contractor, but the investigating officer deemed her an employee because the officer determined she was not engaged in an independent trade or business. We appealed that decision to the deputy. Deputy affirmed that decision. We appealed it to a panel of administrative law judges who reversed prior decisions, sent it back down to the deputy, who eventually determined that the worker was in fact a contractor. Sounds like a win, right? My client, we won. We went through the steps, we won. It took 9 months and cost about $14,000 in legal fees. So that's not really a win, is it? So how do we prevent this from occurring? Well, one way is we can have a properly drafted independent contractor agreement. And these, you can read the factors there. This is, some of the same factors that are made up in the determination in the case that I just quoted, Longview, or it was on the last slide. And, if you put this in writing and you put it in an independent contractor agreement, then instead of the state assuming that the worker is an employee, the state, or presuming more accurately that the worker is an employee, the state and the courts have to presume that the worker is an independent contractor. Now, if you have something in writing that says all this stuff, this person's independent of direction and control and engaged in independent trade or business is kind of what all this sums up to be, then you get the presumption. But if in fact that person is under your control and is not engaged in an independent trade or business, your practices don't match the agreement, then that presumption can be overturned. So, it's a shield, but it's not impenetrable. In any case, if there's any question about whether you are hiring somebody as an independent contractor or an employee, then it's very important to have a good independent contractor agreement in place, because if it's ever a challenge, this will help you quite a bit and help you not spend 9 months and $14,000 to prove it. Before we move on, I just wanted to see if there are any questions.
I just want to clarify, if you're not sure, you're okay with that small business connecting with you, and we're happy to do the introduction so it's an SBDC client.
Sure.
To clarify and to kind of sort through it.
Yeah, I'm happy to offer that free consultation. there are, these requirements are online, and I think there are some independent contractor templates online. I can certainly provide one. As far as doing an analysis of whether an employee or a worker is an employee or an independent contractor, that's something I'd be happy to speak with the group about. Yeah, and it's complicated. Sometimes it's not clear. There's a lot of edge cases where sort of half these factors are in place and half aren't, and the court says it's a totality test, which means we'll figure it out.
Thank
Does
you.
that answer your question, Jamie? Sorry.
Yes, thank you.
Okay, any other questions? All right. I guess one final takeaway is just, if you're really not sure, it's safer to hire them as employees. You can't get in trouble for that. It's just more of a pain. All right, so now let's talk about, the employment term and at-will employment. So now that we've determined that this person actually is an employee, by default, that person will be at will. So that means employers or employees may terminate the relationship for any reason at any time without giving notice or without procedure or formality. That's the common law rule. There have been some things that have occurred to sort of walk that back a little bit in other cases. So for instance, Colorado law now requires that a reason be given for termination. You're required to provide employees with a form that gives them their start date, their end date. I've got a slide on this a little bit later, but we'll talk about it a little bit more. But if you have to give a reason, is it really without notice, procedure, or formality? I think that's getting eroded. Additionally, we can alter the at-will relationship intentionally, by signing a contract or making an agreement, or inadvertently, by inadvertently making a contract. So what is a contract? A contract is an agreement between two or more parties creating obligations that are enforceable or otherwise recognizable in law. It doesn't say it has to be in Times New Roman 11-point font on 14:9 piece of paper, legal paper with signatures attached, right? A contract can be made orally. Contract can be made by people performing a course of conduct consistently over time such that it becomes an unspoken understanding. So you want to avoid accidentally getting into a contract unintentionally. And I'll give you an example. If you have an employment handbook and it contains in it a provision that says, we have a progressive discipline policy. We're going to give you a warning, then we're going to give you a written warning, then a suspension, then you could be terminated, right? And we talk to someone and say, oh yeah, don't worry about it. You have a job. You're good. We really love you. And then that person goes out and does something that really damages the employer's reputation. Maybe they I don't know, steal from a client, it comes out in public or something egregious like that. They haven't received a warning yet. They haven't received a first warning, a second warning. Up until this point, that employee's been great. You've told them now that they've got a job, that you love them, and you've sort of promised that you're going to give them 3 steps before they're actually fired. Arguably, you've given them a contract for a term. You've created some conditions that before which they must be, that must be fulfilled before this person can be terminated. That's why when you see employment handbooks written by attorneys that this is at will, it's written all over it in bold like 900 times, is because even though we want to say, hey, we want to give you this warning and this opportunity to get better, we still reserve the right to just follow the at-will nature and let you go if you do something, or if we just feel like it, frankly. And you want to maintain that as a policy as an employer. In part because, go back to this last slide. in part because where does it get you if you have a contract for a term as an employer? Employers are typically today not incentivized to offer employment for a term because you can't really force somebody to stay and work for you. We abolished forced labor in 1865 when the 13th Amendment was ratified. So having an employment for if your employee breaks that term, what are you going to do? Well, you might sue them. That sounds fun, doesn't it? How many of your employees are worth suing in the first place? Do they have the money to pay you anyway? How does that look? Are courts going to look favorably on a lawsuit against an employee? What's that going to do to your reputation in the community? How much could you actually recover? Most of the time, it's just not worth it. You're not going to sue your employee because they left early. So then query whether it makes sense to enter into extensive contracts or to dictate policies and maintain that at-will employment relationship. The answer is that unless the employee has enough leverage, this is a key employee that you need in the future for whatever reason, somebody that has leverage against you, has a special skill, that has connections, somebody that can demand that you say, hey, you're gonna employ me for 2 years unless I do something really wrong, right? That person might be able to demand an employment for a term, but most employees should remain at will, and we should promulgate more policies than contracts. So again, contract is mutual, enforceable by either party. A policy is typically unilateral, and it's dictated by the employer to the employee as a condition of their employment. Courts have said that employers can change policies really at any time upon notice because they could just fire that person and rehire them the next day instead under new terms. So why not just give them the right to issue new terms and avoid the whole firing and rehiring as sort of a legal loophole to jump through. So policies can be changed at any time unilaterally by the employer. Contracts cannot be. So what are some common employment contracts? Well, the offer letter you give that says it's at-will employment is technically a contract. It should say things like it's subject to our policies. Your employment's subject to our policies. This employment's at will. Here's your rate of pay, but we can change that if we want. Here are the benefits, but we can change that if we want. It's pretty short and simple. Other common contracts that we want to see, these can also be written in policies, but there is something about having a mutual agreement that courts prefer. So when it's really important, it's often wise to have an actual agreement signed. So things like confidentiality, if you have an IP heavy business, same with proprietary information inventions assignment agreement, also called a proprietary rights agreement, or a creation assignment agreement, or about a dozen other names. But what it essentially says is that everything you create while you're working for us using our technology and so forth belongs to us, doesn't belong to you. And that way it's easier especially for startups to demonstrate that they have perfected their intellectual property rights to future investors. So startups with IP definitely want to have these confidentiality and assignment agreements in place. Restrictive covenants agreement, this is, things that the employee can't do after the termination of employment. If the policies are a condition of employment, well, once the employment ends, they're no longer subject to the policy, but a contract can live on past the end of the employment. And then a severance agreement might be something you want to use if you have an issue with an employee and need to solve it and be sure that you're not going to get sued. And you usually would offer some money in association with that. So suggested employment policies, I'm not going to read all of these to you, but they vary greatly depending on what type of business you are. If you're doing cybersecurity, having IT security policies in places can be pretty essential. If you're operating a restaurant, you might want to focus more on things like behavior in the workplace. In any case, what's better, a contract or a policy? It depends on a particular situation, but if you're establishing rules for your employees rather than making agreements with them, it should go in a policy as a general. I'm going to pause there for just a moment, see if there's any questions.
I have a question. Is it legal if you have what you think is a legitimate independent contractor to ask them to sign a confidentiality agreement, or does that then switch it to being a potential employee?
Great question, Jamie. I get this one a lot. You do have to be careful. If you make your contractors subject to your employment policies or start to issue directives to them, then it really starts to look like control, doesn't it? However, confidential information is sort of in its own category. And a good independent contractor agreement should contain, especially if there's IP. I mean, your roofing contractor, I don't know if you really need to sign a confidentiality agreement, but if you're having somebody build your website, for instance, and you're, or build out a pricing model or something that's, involved with intellectual property, then yes, you can and should have them sign a confidentiality agreement. Those are common between lots of different independent contractors and so forth. But I like the way, the question is phrased, which is, kind of, can we apply a policy or can we have them sign a contract? Signing a contract with a contractor is, that sounds right, doesn't it? If we sign a contract with a contractor, and as long as that contract doesn't violate those requirements we looked at earlier that require that the contractor remain free from direction and control in some, then we're good to go. But if we start applying policies to contractors, and we're saying you have to do this or else you're not gonna work for us, well, that really starts to sound like employment, doesn't it?
It does. Thank
Any
you.
other questions before we talk about restrictive covenants in a little more detail?
I don't see any in the chat.
Great. All right, so you've probably heard about non-compete agreements. If you've employed people in Colorado or been employed or signed one of these, you may be aware that they're very difficult to enforce in Colorado. We passed a new law, I think August of 2022, that essentially made non-competition agreements effectively illegal in all but a few specific circumstances, some of which I'm not going to go through here. Like, there's an exception for doctors and their practices, but call me if you have a question about that. So the requirements for an enforceable non-compete is that the employee be highly compensated, which means about $124,000 a year, and that's going up about 10 grand a year on average so far. By the way, we are going to distribute all the slides and the recording. And the restriction has to be narrowly tailored to protect employer trade secrets. So first of all, you have to have trade secrets, which are, things of information of material value that gives you a competitive edge that is, subject to reasonable security precautions, and is more valuable because it is a secret. The traditional example is, the recipe for Coke, but it could be a set of procedures and policies or, sales manual, things like that. But the first question the court's going to ask is, do you really have trade secrets? And if your sales manual is, first call, then introduce yourself, then tell them about the product, that they're not going to see that as a trade secret. It has to be something that is, effectively valuable because it's unknown to the public. And then the restriction can only, restrict the activity to the extent that it's absolutely necessary to protect that trade secret. So what does that leave most employers with in most situations? It leaves us with no ability to restrict competition after the fact, after employment. During employment, employees have a duty of loyalty to the employer, not to compete with them. So that's a different scenario. But as soon as that termination ends, they're free to move on, open up shop next door, and they're free to solicit your customers. The Colorado Supreme Court has determined that it's an essential part of competition is soliciting clients, right? And in many industries, there's fierce competition for few clients. And let's say I'm in aerospace, I want, Ball and Boeing as my customers, and maybe the US government. I probably don't have that many options. If I have a non-compete that prevents me from getting their business, or a provision, a non-solicit that prevents me from getting their business, that's essentially the same as a non-compete. So those are also not allowed. Non-solicitation restrictions on employees, you can't come after your fellow coworker to leave and come with you. That's sort of a gray area. Currently, I think that the Supreme Court is, waiting for some more stuff to happen to issue a determination on it, but it is at least conceivably possible to prevent your employees from soliciting your other employees after they leave.
Nathan, excuse me for interrupting, but does that apply to if you have a business partner as well?
So this is a new law, Jamie, and I just had this very long argument with an investor who's becoming a business partner with my client, and of course wanted non-competition restrictions on my client. And my argument was, of course, this applies. The statute references workers. It doesn't say that if it was only an investor that was being restricted, that didn't actually work for the company, like a silent investor, then maybe you could restrict that person. I mean, this is my take on it. This is still being worked out in the courts. Then maybe you could restrict that person, but the member or the partner who's actually working in the business is a worker, and the statute says you can't restrict workers. So I think that the answer is no, that it still applies to your partners. There is a sale of business exception. So if your partner is selling you half the company and you're being bought out, they might be able to get you might be able to enforce a non-compete against them. Or if you sell your entire business and the buyer wants you to sign a non-compete, that can be done. My opponent's position was that this is about an investment. It has nothing to do with workers. We're talking about the capital structure of the company, and it's, even though they are workers, it's in their capacity as partners, not in their capacity as workers. And what we ended up doing was signing a non-compete that I don't think will be enforceable, and he does, and we did it just to get the deal done. Not my favorite outcome, frankly, but it was a 7-figure investment that my client really needed. So we did it with the knowing that if it ever came down to litigation, my opinion was that we'd win. So that's a long way of saying it's hard to tell, I guess, and it depends on the facts. Sorry for the dissertation there. All right, so what happens if you do it? If you use coercion, you threaten somebody, that can actually be a crime. I expect that's not going to pop up for most of us here. The worker's actual damages. So say they lose their job because you threaten to sue them and you tell their new employer that they've got this restriction. Well, you might be liable for the wages that they lost as a result of that, plus just $5,000 per worker, and attorney's fees and costs, which is likely to eclipse all of that if you end up going to trial on it. Again, at this point in Colorado, my advice is to be kind to your employees, incentivize them, provide them a good place to work, and try to keep them that way, as opposed to threatening to restrict them or sue them after they leave. First of all, it's just suing folks is not a good time. And it's, in this situation, it's going to be very difficult to win. Public policy wants to encourage a free market and competition, and allow employees, the workers, the right to make a good living using the skills that they've acquired. And so you're really swimming upstream trying to enforce restrictive covenants, and especially in this state, and really across the Western United States. These are still kind of, they still work in places like Delaware and New York, but in California, Washington, Oregon, Nevada, you're not going to get away with this either. And I think it's changing. The FTC is considering a rule change that would make that would restrict non-competitions nationally. So, even though my East Coast opponent there kind of got his way in the long run, I think that his hope of if they ever tried to enforce it, I think they'd lose, and they'd probably spend a whole lot of money trying, and it would never be worth it. So, I think for employers, especially in today's labor market and the way these policies are going, it just makes a lot of sense to focus on incentives rather than disincentives. All right, let's talk about our next favorite topic. Are you guys having fun yet? Aren't these like the most fun subjects that you want to, think about all night? All right, so separation of employment, termination. Most of this is common sense, but it matters as far as how the law is applied. We have voluntary and involuntary termination, right? Employee leaves, I quit. Voluntary, involuntary is you're fired, or which is for cause, or sorry, we have to lay you off, or we're just letting you go, not for cause. So involuntary separation triggers rights under the Colorado Employment Security Act, known as CISA. I think it's actually the Colorado Employment Security Act, but I may have that wrong. There's a lot of text here, but essentially what the Employment Security Act does is it provides unemployment insurance benefits to employees, and it requires that employers make contributions to the insurance fund, and that you provide certain notices to employees. So that you got to print a poster and put it up somewhere obvious that contains the first 4 bullet points. And then you have to provide, when you let somebody go or they're terminated, you have to provide the next, whatever, 8 or 9 bullet points in a form that the Department of Labor, you can find it online if you just Google Colorado Employment Separation Form. The last bullet on the notice that you have to provide to your employee is what I mentioned earlier, is the reason the employee separated from the employer. And what we don't know yet, because it's still very new, and as I mentioned, a lot of these laws are changing very quickly, is what exactly the legislature meant when they put that in. We have to provide a detailed explanation of why that we felt it was necessary to terminate, or a detailed explanation of our financial situation if they were laid off because we can't afford them. We don't really know. And my advice to clients currently is to leave this pretty broad. If it's for cause, you say failure to comply with requirements, or failure to comply with perform job duties, or both, something like that, as opposed to saying didn't show up for work Monday morning, didn't call. If we leave it broad, in the event we ever come back to a hearing, we have the opportunity to make every good argument that we can think of. Whereas if we narrow it down, they're going to say that's not what you put on the form, where you're making this up after the fact, right? So we want to leave our options open. I expect we're going to see some case law at some point that provides a little bit more direction on what exactly needs to be included here. And frankly, I expect when it comes down that it'll probably, be a little bit more than I want to put in there. And the reason is that, the rest of this stuff is designed to allow the employee to give them the information they need quickly and easily to go get unemployment insurance. And, if they have a very specific reason that you have to write down that says why they were fired, it's going to make it easier for them to challenge your for cause termination and get those benefits. So maybe I should back up just 1 second. If an employee is fired for cause, they did something that violated policy, a contract, or did some generally egregious things, then they're not entitled to unemployment insurance benefits. But if they're laid off for not for cause, the employer just couldn't afford them anymore or wanted to move in a different direction, then you can get unemployment insurance benefits. So for cause or not for cause matters. And why do you care if you terminate people not for cause and the unemployment insurance company has to pay out more payments? They're going to raise your premium. It's going to cost you more money. Just like if you get in a lot of accidents in your car, your insurance premium is going to go up. So that's why you care. So voluntary separation does not involve a ton of legal complications. The employee has to return property, keep company confidential information, and anything else you put in a contract. This might, for employees with a lot of knowledge or passwords and things like that. And, there may be some transition services. You may say, hey, you need to help us get this, or, obligation of continued cooperation. You might ask them to sign a non-disparagement agreement as part of one of the earlier agreements that I mentioned earlier, or a severance agreement that includes that. You think they're going to go out and talk bad about you in the community. You want to get ahead of that potentially. And really anything else you can think of, as long as it doesn't violate one of the other dozen rules that we're discussing today, right? Employer's obligations upon voluntary separation, when the employee quits, is you have to pay all amounts earned indeterminable at the next regular payroll cycle. So just when the next payroll comes out. And what are wages earned indeterminable? I mean, basically they're anything that the employee has earned that there are no more conditions for them to have to satisfy to get. So vacation counts, accrued vacation. So if you got an employee with 80 hours of accrued vacation that's worked for you for 40 years or whatever, and they quit, you have to realize that that's a liability on your books. You're going to have to pay those 80 hours out on the next payroll cycle. An example of something that's not earned indeterminable is sick pay. Sick pay is requires that you get sick first before you use it. So that condition hasn't been met, and the courts have determined that that's not earned indeterminable. So you sort of have to look at those things. Where this comes up a lot is in commissions. We see employers say, "Oh, well, we never got paid for that, so we don't owe you that commission." Well, and if it doesn't say the employer has to be paid for the employee to earn the commission, that's still payable. So it's important that you identify clearly when commissions are earned, so you don't end up paying out commissions for which you've never received payment, or for which not all steps have been completed. I probably had to speed it up here. Sorry. COBRA. And obviously there's notices you have to provide if you're providing health benefits. And then after the fact, I get the question a lot, do I provide a recommendation? Well, if you provide a negative recommendation, if you say, I don't think you should hire this person, or they weren't a great employer for me, that opens you up to some liability. A claim might be intentional interference with business relations, or disparagement of some sort. Or defamation, of some sort. So it's really just better to just, say, hey, this person worked here from X and Y date, between X and Y dates, and had this title, especially if it's a negative review. If you want to leave a positive review, I think that's more acceptable, but, it starts to create issues between employees and former employees. And, many employers find it simpler and easier to just say our policy is to just confirm the title and dates of employment, and that's all we're going to tell anybody that asks. All right, involuntary separation. This is firing not for cause. Basically, when the employer's will, right, at will, is to not have the employee employed anymore. You have to tell them it's for cause at the time on that sheet. You can't later dispute the unemployment insurance claims if you don't tell them it's for cause at the time. All wages earned indeterminable must be paid immediately, whereas if they quit, you get till the next payroll cycle. But if you fire them, gotta give it to them on that date, and at the firing, basically, unless your accounting office or your accounting unit is offsite, in which case you have 24 hours. But best to just have the form and the check ready to go. What to list? We talked a little bit about that. The information on this form here, most of it's just dry facts you got to list, and then the reason, I would say keep it broad. Give me a call. I'll be happy to help you formulate that. And then consider the circumstances. Does this employee have a legitimate gripe with you, or a gripe that might sound legitimate to a third party is really how you should evaluate it, not whether you think it's legitimate, because if you're the employer, you probably don't. But how does it look? How's it going to look in court? How's it going to look to the Department of Labor? The Department of Labor I've mentioned several times, is, has a lot of power in Colorado to enforce all these rules and regulations. In a lot of ways, they're kind of the judge, jury, and executioner. You can always appeal that up to a regular district court. But again, think about my client where we won that classification hearing, and it cost her 14 grand in 9 months. Yeah, you can keep fighting it, but it's not free unless you do it yourself, which is difficult. So if you're letting someone go and you think there might be some facts that aren't going to look good, and there's some threats floating around, or sometimes you just want to take care of somebody, you might offer this, but really it's a quid pro quo for their agreement not to sue you, to drop all the claims that can be legally dropped, etc. And not all claims can be legally dropped. For instance, a wage claim, like the one we just talked about, where you didn't pay everything that was owed on separation. You can have an employee sign something that says they waive those rights, but the law says they still have them. All right. This is for cause. This is pretty self-explanatory here. People don't show up, they're insubordinate, they're incompetent, they steal from you, then you can fire them for cause. Another way that you can fire people for cause is if they fail to follow your policies, that's in blue, or if they breach a contract that you have with them. So if you want to expand the reasons that you can fire somebody for cause, you want people to perform a certain way, and you have certain expectations of them, and you want to be able to let them go without any comeback on you. If they don't do that, then it's important to get a policy or contract in place. Otherwise, you're really kind of relying on this basic list, and you're going to end up paying unemployment insurance benefits. All right, questions on firing or quitting? I mean, I guess my best advice is, hire slow, fire fast. It's never fun to let people go, but employees are difficult and expensive. And if you take your time in selecting them, and when you figure out they don't work, you let them go sooner rather than later. Usually we don't see a whole lot of backlash from that. All right, so I kind of skipped ahead to this slide. The enforcement arm in Colorado is the DOL, or DOLE, Labor and Employment. Formally, the rule maker. They make up the rules, they investigate them, and then they decide whether you've broken them or not. So again, judge, jury, and executioner. You can appeal from their top layer. There's several levels of appeal I described earlier. You can appeal past that to a district court, but you have to go through the administrative process before you can take advantage of the regular legal system, and that's cumbersome. I think we just talked about this. Wages earned and determinable must be paid on separation. Voluntary next regular payday, involuntary immediate or next business day. If you get a notice from an employee that you haven't paid him enough, there's a statute. The employee by law has to give you a notice, and then they can report this to the DOL, who will enforce their rights, investigate, see if they've actually been underpaid, and then you can potentially have to pay as much as triple damages. Additionally, the employee can just sue you in regular court to recover as well, and if they win there, they'll get their attorney's fees. They don't have to pay the Department of Labor anything to enforce their rights, so that's usually what employees will do. Okay, so we talked a little bit about how the government regime has started to put more and more of these sort of social welfare burdens on employers. This is it right here. The Colorado Healthy Families and Workplaces Act is basically a leave act that it applies to all employers in Colorado now. Most of the acts federally require that you have at least 15 or 50 employees. Depends on which law we're talking about, but the Colorado laws are starting to apply to just about everybody. So you gotta now let folks accrue sick leave. You don't have a choice. You gotta give them 1 hour of paid time off for every 30 hours worked, capped at 48 hours per year. They can be taken for any medical reason by victims of domestic violence, criminal harassment, I believe also for the deployment military deployment of a family member, and maybe a few other things. You can request documentation about the reason for the leave, but only if it's more than 4 consecutive days. So, it may seem like the most natural thing in the world to say, hey, what's going on? You got to take family and medical leave for 3 days. Tell me what's up. You're not allowed by law to even ask unless it's 4 days or more. So this was more interesting last year, but there is still a law in the books for public health emergencies, such as the COVID public health emergency that we had, which lasted for close to 3 years, I think. It requires that you provide an additional 80 hours of paid sick leave per employee for the duration of the public health emergency. So that 3-year public health emergency we had in Colorado, and that's by declaration of the governor, that's a legal thing. It's not, whether I think it's a public health emergency, it's whether the governor declares a public health emergency. Then you have to provide them 80 additional hours of paid time off. You're not allowed to ask for documentation. So if your employee says, rewind, I had this happen a lot at the end of the pandemic. Employers say, my employee says he's got COVID, he's been out for a week and a half, and I don't think he's actually sick. So, tough rocks. You got to just live with it. You can't even ask him to prove that he's got COVID, show you a test, et cetera, et cetera. So that's the law. We are not in a public health emergency currently, so don't worry about it until the next pandemic or whatever terrible thing happens next, I guess. The Colorado Secure Savings Program Act is essentially, Colorado joining the federal government in providing a Social Security plan. So it's a retirement plan, applies to employers with 5 or more employees, and who have not offered a qualified retirement plan in the last 2 years. So basically, you either have to offer your employees a 401k or some kind of sponsored IRA, or you have to have a plan in place, or you have to use the state-sponsored plan. So, this began last year, about a year ago, and a phased rollout. I believe actually this is going to apply to all employers in 2024. May not have updated this slide since 2023. So,
Nathan, I'm sorry for interrupting, but I understand that you have to offer them, either you offer it or you offer them the state plan, but do you need to contribute to that state plan as an employer?
Yes, you do. I believe it's I want to say 0.9% of the employee's wages, and I believe that's split between the employer and the employee, but both have to make contributions. Yeah. And it kind of works the same as a private, 401k. There's the employee makes contributions and the employer usually matches it. So that's it's designed to just force employers to have a retirement plan of some sort.
So what if the employee turns it down and says, I don't want to contribute, so I don't want that? Is that okay then, or no?
I don't think so. I haven't spent a lot of time with this law, but I believe it's mandatory. There may be, there's always exceptions, and I know there's some exceptions for certain plans, but I believe the default is that, there has to be a plan in place, and it has to be sponsored by the employer and the employee.
Thank you.
All right. Colorado, basically Colorado's version of the Family and Medical Leave Act, applies to pretty much everybody. There's a few exceptions, but they're usually like state entities, local governments, that kind of thing, that already have extensive, state leave programs in place. As we get, what I must have been thinking of I said 0.9%. I was thinking of this slide. I don't know what the contribution for the retirement is, Jamie. I'd have to look it up. Nobody's been getting sued over it yet, so I wasn't getting calls. But so the employer contributions, should have begun January 1, 2023. 0.9% of wages split between the employee and the employer. This provides it's a paid medical leave program, which, the FMLA, the federal leave program, gives you time off, but it doesn't give you any money for it. Benefits are available now this year. Employees are entitled to take up to 12 weeks off for, personal health conditions, those of a family member dealing with domestic violence or harassment or military deployment. And then, obviously pregnancy is a serious medical condition, and we get an additional 4 weeks off for that. So, what it means for employers is more or less that, you need to be paying into this program and signed up for it. And that if your employees take this time off for, for a reason that's, fits the bill, then, you can't fire them for that. Like if they say, hey, I'm having a kid, I'm taking 12 weeks off, actually 16 weeks off, then that's not a terminable reason. It's not a reason for termination. But you don't pay the wages. I mean, you got to pay that 0.45% into the program, but then the state pays the wages that are out. And it's not a ton. I believe it's a few $100s to a maximum of $1,100 per week. So depending on the type of employee that you have, that may or may not, compensate them fully. And I believe the division determines that, the DOL determines that based on average weekly wage. All right. Any questions on those laws? Any more questions on those laws?
No,
All right.
but we are at time, but I'm hoping you'll continue. And those of you who have a time constraint, you can leave the call and we will continue to record and send you the recording so that you'll have the full session.
Thank you. Sorry for going over. This is our last topic. We're almost done here. So how not to get sued. So first of all those laws we just mentioned, be careful to try and comply with them. The Department of Labor, is a great resource. They're happy to answer your calls and help you be in compliance. And they put out a lot of information online that is usually pretty well packaged. So, look it up through the Department of Labor. If you're not sure, give them a call. They're pretty helpful. It's free. They want you to follow the rules and understand them. They enforce them as well, but their preference is that you just follow them in the first place. So they're happy to help. Usually, I can't make that unequivocal promise for every government employee, but in my experience, they've been happy to help. So the next thing is employment discrimination, and the most people think I cannot discriminate. Well, you have to discriminate, otherwise you'd have to hire everybody, right? You have to discriminate against some folks. Maybe this person has a degree and this person doesn't. This person has 10 years of experience in the field. This person's just coming in. This person demands X salary and I can pay this person less. Those are all fine reasons to discriminate. What you cannot discriminate on is race, color, creed, national origin, ancestry, sex, age, sexual orientation, and physical or mental disability, except that, if a disability prevents them from performing a core job function, you're not required to hire them. So, how do you get caught with discrimination? I mean, hopefully not a lot of us are intentionally discriminating against anybody. And those of us that are usually not, stupid enough to say, I'm not going to hire you because you're old or because you're pregnant or because you're gay or whatever. People aren't that dumb anymore. So the way that discrimination is shown is through effect. An example is a company in Georgia required health screenings and disqualified those with sickle cell anemia from certain jobs. Well, because African Americans have a higher incident of sickle cell anemia, the court found that was discriminatory in effect and violated labor laws, excuse me. So it doesn't have to be, you don't have to intend to discriminate. If your practices and policies result in discrimination, that's still illegal, right? Probably an even more common way to get in trouble is for retaliation. And so this is when somebody, reports a protected activity, reports discrimination, either to you, to a coworker, to, an agency, a government agency, to an attorney, to whomever, really. If somebody says, hey, I was sexually harassed at work, and you say that's not true and fire them for it, you're almost certainly going to get in trouble for retaliation, even if the sexual harassment alleged never occurred in the first place. So, you have to be careful when people make allegations. The best practice is to take them seriously, perform a thorough investigation, evaluate your options. If you're some gray areas, call your attorney. And unfortunately, you just can't gloss over any allegations of discrimination, hostile workplace, which requires discrimination, by the way. You can be a jerk to your employees as long as you're a jerk to everybody equally. You just can't be more of a jerk to protected populations. There's case law on that. So, again, be very careful how you handle an allegation. I mean, you may find it frivolous. You may want to just fire somebody for making the allegation, and that will almost certainly land you in court. Other ways, if you have employment contracts and agreements, then, you need to follow them as well. And I see this in a lot of employee handbooks and policies, and they say, we sit down and we say, we're going to do all this stuff. We're going to do quarterly performance evaluations, and we're going to, find you some benefits as soon as we can. And then, life happens. You don't end up doing the reviews, don't end up purchasing the health insurance. And now maybe you're in breach of your obligations to your employees, and they can sue you for that. So my advice is to start small with, your promises to your employees. You can always be nicer than your contracts, give them more. But if you give yourself obligations and then don't follow through on them, that can land you in hot water. And then finally, I think, we talked about the Department of Labor, but just understand that for most of these, like for discrimination, for, violations of the various acts, the employee does not need to hire an attorney. They have a free resource in the Department of Labor, and you are going to have to hire an attorney. So there's a disparate expenditure of resources to contest these things. And so it makes a lot of sense to try to get out in front of these and get your labor practices dialed in so that you don't have to hire Max in the long run. Okay, that's it. Thank you. And we did, Jamie, I went so far over. I'm sorry. I still have time for questions from people if anybody has time and wants to ask them. But if everybody, I understand as well.
Well, first of all, I would like to say thank you for offering not only to host all these workshops for us at our center, but to also offer your 30-minute no cost confidential conversation. Oh my goodness, that's hard to say. For small businesses that have questions, because I have to say it's gotten more and more complex. And it applies to just about every business. As you said, you believe in 2024, it will apply to all businesses.
Yeah.
So thank you for your time. You can reach out to Nathan directly, or we're happy to do an introduction. And we also have to provide 3 other lawyers, so we'll be able to supply you with that information as well. And we're going to go ahead and turn off the recording and open it up to any